Good afternoon, everyone. So thank you very much for joining our webinar today. I am Emma Waldron, WCVA's Risk, Procurement and Governance Manager, and I'm WCVA's Data Protection Officer. This is our fifth webinar of the Desktop Data series, and the sessions have been arranged to help you prepare for the new General Data Protection Regulation, also known as the GDPR, which comes into place in May 2018. And I'm delighted to welcome our speaker, Bethan Bonsall from the ICO.
Hello.
And Bethan's here today to discuss the Privacy and Electronic Communication Regulations, which during her presentation she'll also refer to it as PECA or the PEC regs. So we anticipate that today's session should take approximately 35 minutes and there'll be an opportunity for questions. So feel free to add your questions to the chat pane during the session, and we'll be answering them halfway through this webinar and then again at the end. So over to you, Bethan.
Thanks, Emma, and thanks to you all for joining us in our webinar on the Privacy and Electronic Communication Regulations. As Emma said, throughout I'll be referring to them not just in their full name but also by PECA and the PEC regs, just to save you from getting fed up with the same terminology. Now, before we make a start, it's hopefully going to be useful if I explain a bit about the role of the ICO for those who aren't as familiar with our role. So the Information Commissioner's Office is the UK regulator for the Data Protection Act, Freedom of Information Act and the Environmental Information Regulations. We also regulate the law that will be the focus of today's webinar, which is the Privacy and Electronic Communication Regulations, and that law governs how you as organisations, including charities, send direct marketing by electronic means. Although the Data Protection Act isn't the main focus of today's webinar, it's important to be aware that the Data Protection Act will be replaced next May by the General Data Protection Regulation, which is the biggest change to data protection law in a generation. For those of you who aren't familiar with the changes that the GDPR will bring in terms of how you process personal data, we ran a webinar in May this year outlining the 12 steps that you need to be taking now in order to prepare effectively for the change in law. And that webinar can be found on WCVA's website under the Desktop Data series. So if you haven't had a look at that, I would certainly recommend doing so. Back to today's presentation. So the purpose of today's webinar is to remind you of your obligations under the Privacy and Electronic Communication Regulations. But before we go on to discuss them in more detail, what exactly are the regulations? So as you can see on the screen, the PEC regs sit alongside the Data Protection Act, and they give people specific privacy rights in relation to electronic communications. So that's things such as emails, telephone calls and text messages. It's important to note that the Data Protection Act still applies if you're processing personal data. The PEC regs just set out some extra rules for electronic communications. Although the Privacy and Electronic Communication Regulations cover several areas, the focus of today's webinar will be on electronic marketing, and we'll be looking at the ways that the regulations protect people's privacy by placing restrictions on the sending of unsolicited electronic marketing messages. However, the regs also apply to you not only if you market by phone, email, text or fax, but also if you use cookies or a similar technology on your website, or if you compile a telephone directory. Now, we won't be focusing on directories today because the definition is basically a directory of subscribers, whether in printed or electronic form, which is made available to members of the public or a section of the public, including by means of a directory inquiry service. So it basically means that those internal directories that you have regarding your own staff or customers will not be covered by this element of the PEC regs, but will obviously still be covered by the Data Protection Act. Now, if you would like to find out a bit more about your obligations when compiling directories, then please do visit our website because we do have detailed PEC reg guidance on there as well. So let's firstly take a look at your obligations if you use cookies on your website. Now, unfortunately, the cookies that we're talking about aren't the nice kind that we can see on the screen, but which kind are we talking about? A cookie is basically a small text file that's downloaded onto terminal equipment, so for example, a computer or a smartphone, when the user accesses your website. So it allows your website to recognize that user's device and store some information about the user's preferences or past actions. So if you do operate cookies on your website, what do you need to do in order to comply? The rules on cookies are in Regulation 6 of the PEC regs, and the basic rule is that you must tell people that the cookies are there, explain what the cookies are doing and why, and also, importantly, get the person's consent to store a cookie on their device. So as long as you do this the first time you set cookies, you don't necessarily have to repeat it every time the same person visits your website. But however, it's important to bear in mind that some devices, for example, a family computer, may be used by different people. So if there is likely to be more than one user, then it's good practice to consider repeating this process at suitable intervals. So that would be determined on, your own decisions. There is an exception for cookies that are essential to provide an online service at someone's request. So an example for that would be to remember what's in someone's online basket or to ensure security in online banking. Again, this is just a quick overview of your obligations under PECA when you're using cookies, and further information can be found on our website. Now we're going to look a bit about direct marketing, but I'll just note now that we won't be covering postal marketing because the focus of today's webinar is obviously the privacy and electronic communication regs. So we'll only be looking at direct marketing by electronic means. But again, we do have useful guidance on our website if you're postal marketing and you want to remember what your obligations are under the Data Protection Act. So let's take a look at what we mean by direct marketing before we go on. So first of all, direct marketing covers all advertising or promotional material, including the promotion of the aims or ideals for not-for-profit organisations. So for example, it does cover you as a charity or a political party campaigning for support or funds. The marketing must be directed to particular individuals. So in practice, all relevant electronic messages, so calls, faxes, texts and emails, are directed at someone. So they do fall within this definition. Genuine market research does not count as direct marketing. However, if a survey then includes any promotional material or collects details to use in future marketing campaigns, the survey is therefore for direct marketing purposes and the PEC Reg rules will apply. And it's important to note that routine customer service messages do not necessarily count as direct marketing. So in other words, correspondence with customers to provide information that they genuinely do need about a current contract or past purchase. So for example, information about service interruptions, delivery arrangements, product safety, changes to terms and conditions, etc., will not count as direct marketing. General branding, logos or strap lines in these messages do not count as marketing either. But the important thing to remember is that if the message then includes any significant promotional material aimed at getting customers to buy extra products or services or to renew contracts that are coming to an end, that message includes marketing material and the rules of the PEC regs will therefore apply. So we're now hopefully clearer on what the definition of direct marketing is, but what types of electronic marketing do the PEC regs cover? So any marketing carried out over the phone, whether it's calls initiated by a person or by automated means, by fax, by email, and any marketing undertaken by text message. So all of those are covered. It's important to note that before we look into more of these in detail, that we're talking here about unsolicited marketing messages. So put simply, a solicited message is one that's actively requested. So if someone specifically asks you to send through some information, you can do so without worrying about the privacy regulations. Although obviously you must still say who you are, display your number, etc. when making calls, and provide a contact address. So an unsolicited message is any message that is not being specifically requested. So even if your customers have opted in to receiving marketing from you, it still counts as unsolicited marketing. An opt-in means that the customer agrees to future messages and is likely to mean that the marketing complies with PECA, but this is not the same as someone specifically contacting you to ask for particular information. So that's the key difference between unsolicited and solicited. So let's look firstly at your obligations when making live marketing calls to individuals, which I'm sure many of you will do. So if you do, then these rules will hopefully be important and useful for you. So the rules on making live marketing calls are in Regulation 21 of the PEC regs. So in short, as you can see on your screen, you must not make any unsolicited live calls to anyone who's told you that they don't want your calls, or any number that's registered with the telephone preference service or the corporate telephone preference service. So unless the person has specifically consented to your calls, so even if you're an existing customer, if they're registered with the TPS and haven't told you that they'd like to receive marketing calls, You cannot direct market them in that way. You must also always say who's calling. You must allow your number or an alternative contact number to be displayed to the person receiving the call, and you must provide a contact address or free phone number if asked. So that's live marketing calls. But before we go on to talk about what you must do to make sure you're getting the law right when making automated calls, I just want to get a feel for how many charities listening today do actually instigate automated marketing calls. So that is any marketing call that consists of an automated message. So the person isn't speaking to a live person, they're greeted instantly with an automated message. If you do instigate these types of calls, if I could just ask you, using the green ribbon at the top of your screen, to agree or disagree by using the options on the ribbon, or if you can't find out how to vote that way, if you could just type in agree or disagree in the chat pane. So basically, agree if you do make automated marketing calls as a charity. If you don't, then either disagree by the green ribbon or just type in disagree in the chat pane. So if I could let everyone do that now.
Okay, so far looking at some of the results, some people are voting here, and we have the majority disagree and don't. 1 or 2 are agreeing. Yep, so the majority disagree there, Bethan.
Brill. So basically, regardless of how many of you do instigate these at present, it's really important to be aware of the rules surrounding them. And that's because automated calls are very privacy intrusive. So have a think about how you feel when you've received an automated call in the past. I'm sure we all have at some point, I certainly have. By their very nature, automated calls are far more frustrating than those involving real people at the other end. And that's because you can't glean any information from the company or charity as to how they got your details. And you can't also ask them to stop calling you because you're simply speaking to a recorded message. So due to the fact that they are more privacy intrusive than live marketing calls, the rules governing when automated calls can be made are therefore stricter than when making live telephone calls. So let's look at those rules. Just going to click to the next screen. So the rules on automated calls are in Regulation 19 of the PEC regs. You basically must not make an automated marketing call, that is again a call made by an automated dialing system that plays a recorded message, unless the person has specifically consented to receive this type of call from you. General consent for marketing or even consent for live calls is simply not enough. It must specifically cover automated calls. All automated calls must include your name and a contact address or free phone number. And you must also allow your number or an alternative contact number to be displayed to the person receiving the call. And just as an aside, because automated calls require consent, so you can't kind of infer any consent any other way, it's got to be specific consent, now is a really good opportunity to pause and have a quick think about how you actually obtain and record consent within your own charity. So, as mentioned at the beginning, data protection laws are changing on May 25th next year when the GDPR or the General Data Protection Regulation comes into force. And many of you will be aware, but for those that aren't, the rules surrounding consent are far stricter under GDPR. So in short, if you're relying on consent as a basis to use someone's data under GDPR, so after May next year, that consent will require a clear affirmative action. So me as the individual, I've got to take a clear action to opt into something. So consent by silence or inactivity, such as the use of a pre-ticked box, or silence, meaning that I consent to something, will not be GDPR compliant. So again, I refer you back to those 12 steps to take webinar that we did in May, but also the ICO's guidance on GDPR as well. Now, I've probably overloaded everyone with information, so I think now is a good opportunity to stop and see whether there are any questions that you'd like me to answer at this stage. So I'll hand you to Emma.
Okay, so just a reminder to those of you that voted using the agree or disagree buttons, if you can clear your status as well, because we'll be asking you another question later on during the presentation. And anybody that's got any questions, if you can start typing them into the chat pane. So we do have a few questions. So a question from Bethan on what constitutes direct marketing. Would an email containing joining instructions to a conference be exempt, as the person in question has already booked their place at the event and the email is for information only?
Brill. Thanks for that question, Beth, and that's a really interesting question. And it's basically, it's important to know the kind of content in that email. So if that email was simply just linking to the joining instructions, even if you had your kind of your symbol of your organisation in the letterhead, or sorry, in the email signature, then as long as it's just explaining how they then join that conference, then that's unlikely to be captured by the privacy regulations. So obviously it's still data protection because it's still using their information, but it's unlikely to constitute direct marketing. Now, if you then went on in that same email to kind of promote the aims or ideals of your charity, then it's likely that that's bordering on direct marketing, and in that case you'd have to consider compliance with the PEC regs. So I hope that's useful, but that's a very valid question. Thank you.
Okay, thank you. And then another question is, do we get a copy of the slides? So a copy of the presentation isn't available as such, but this presentation is actually being recorded and will be available online afterwards. So we really do promote you sort of sharing this with colleagues and contacts as well. And another question, okay, so I believe Leela's answered the one regarding the screen. Question from Adam, where you have a network of business contacts that you use, inviting organisations to events, is this covered by the Act?
So that's also a good question, so thank you for that. Now, the privacy and electronic regulations do differentiate the rules slightly in respect of individual subscribers and corporate subscribers. So it's important to note here that a corporate subscriber would, for example, be the ICO's corporate email account. So something like Wales@ico.org.uk. So if you're sending organisations to events to those kind of mailboxes, then there's slightly differing rules, but there's still very strong rules in respect of the privacy of those people within organisations when you're using emails such as, for example, mine is bethan.bonsall. So that's clearly my personal data. I've got rights in relation to that under the Data Protection Act and under the privacy regulations. So that's a very valid question. In order to kind of get the full information as to what you're required to do when you're emailing either individual or corporate subscribers, our guide to the privacy regulations will hopefully be very useful. But the kind of key is that there are rules that do govern the use of corporate email addresses. But yeah, there's more guidance on our website. And then if you've got any questions following that, then you're more than welcome to get in touch with the Wales office.
Okay, thank you, Bethan. And just to add, regarding the telephone preference service and the corporate telephone preference service, so if you want to find out any more information about that, the website is www.tpsonline.org.uk, and for the corporate TPS registrations, they will last for a year, so they need to be renewed every year, whereas the residential telephone preference service, I believe once your number is registered on there, it's registered permanently until it's requested to be removed.
Yeah, and I would encourage all of you in capacity as an individual, I'd recommend that you do register with a telephone preference service, because if you phone the ICO to complain about a marketing call that you haven't consented to, the first thing we would ask is, are you registered with a telephone preference service? So if the answer is no, we would say, go and register. And then after 28 days, so once that registration has come into effect, you've got stronger grounds then to complain about the kind of receiving of that unsolicited live marketing call.
Okay, thank you, Bethan. So I think what we'll do at this stage then is we'll carry on with the presentation, and then at the end there will be an opportunity to ask further questions.
Yeah.
Okay, over to Bethan, thank you.
Thanks, all. So let's move on now to the sending of marketing material by faxes. So fax marketing isn't used as regularly these days as it perhaps used to be, but it is still important to have a look at what you need to do if you do send direct marketing materials by faxes. So the rules on marketing faxes are in Regulation 20 of the Privacy and Electronic Regulations. And in short, you must not send marketing faxes to, first of all, individuals, including sole traders and some partnerships, unless they've specifically consented to your faxes. You must not send them to a company or other corporate body that has told you they don't want your faxes. And you must not send faxes with marketing material if a number is registered with a fax preference service. So that works in a very similar way to the telephone preference service. unless the person has specifically consented to your faxes. So if they've registered with the FPS, but they've actually, aside of that, told you, I am FPS registered, but I do consent to faxes, then that would be their kind of consent to receive those marketing materials. And all marketing faxes must include your name and a contact address or free phone number, in case the individual wants to get hold of you to change their preferences, etc. Now, before we go on to the rules governing what you can send in terms of electronic mail, what do we actually mean by that term? Because it's quite a broad term. Under the PECA, electronic mail can mean emails and texts, but it can also extend to things such as electronically stored messages, which does include email and text in themselves, picture messages, video, voicemail, answer phone, and even some social networking messages. So as you can see, and as I just mentioned, electronic mail is quite a broad definition. But primarily, the electronic mail that you send would likely be text messages and emails. So when can you lawfully send direct marketing by electronic mail? So organisations can generally only send marketing text or emails to individuals if that person has specifically consented to receiving them. When sending marketing messages by electronic mail, you must not disguise or conceal your identity, and you must provide a valid contact address for individuals to opt out or unsubscribe, which would basically mean that they're withdrawing their consent. And it's good practice to allow individuals to reply directly to the message and opt out that way, to provide a clear and operational unsubscribe link in emails, or at least to provide a free phone number so that they can get in contact with your organisation or charity and let them know that their preferences perhaps have changed. And although organisations can generally only send marketing text or emails with specific consent, there is an exception to this rule for existing customers, and that's known as the soft opt-in. And it basically means that, just lost my place. Organisations can send marketing text or emails if they've obtained the contact details in the course of a sale or negotiations for a sale of a product or a service to that person. They're only marketing their own similar products or services, so no one else's, and you gave that person a simple opportunity to refuse or opt out of that marketing, both when first collecting their details and in every message after that. But as you can see on the screen, it's really important for you as charities to note that text or emails must be marketing products or services, which means that the soft opt-in exception can only apply to commercial marketing. Charities, political parties, and other not-for-profit bodies will not be able to rely on the soft opt-in when sending campaigning texts or emails, even if those are to existing supporters. So in other words, text or emails promoting the aims or ideals of your organisation can only be sent with specific consent. So now that we've looked at the rules that govern direct marketing, let's just have a quick think about why getting it right is so important. Firstly, individuals trust you to handle their data correctly, and that's when they interact with your charity. So at the point they hand over their data, they've got that level of trust. If you take their information and use it in then ways where they wouldn't expect, then that's more than likely to remove the trust that they had in your charity. So getting direct marketing right and following the law allows individuals to have control over their information, and it will empower them and lead them to having trust within your charity. So that's a big bonus. And then secondly, getting things wrong under the law when it comes to direct marketing can lead the ICO to take enforcement action. And the information that you'll see on the screen is a screenshot of the action that we took in August in relation to direct marketing. And as you can see, 3 companies were issued with civil monetary penalties. So when we fine organisations, we call them civil monetary penalties. And they received those fines after calling people who were registered on the telephone preference service. So they hadn't screened their own databases against the TPS. We won't look at all 3 cases in detail, but it's useful to have a bit of background, so we'll just look at one. So in the case of Virgo Home Improvement, between 6th of April 2015 and the 22nd of November 2016, the Commissioner received a total of 440 separate complaints about unsolicited direct marketing calls made by Virgo. So during the Commissioner's investigations, it was found that 345 complaints were made directly to the TPS, with a further 95 made directly to the ICO via our own online reporting tool. So all of these complaints were made by individual subscribers, so us as individuals, who had previously notified Virgo Home Improvements that such calls shouldn't be made on that number, or they'd registered their number with the TPS. How do these make people feel? So we've all had calls, and I'm sure we've all experienced the frustration of having an unsolicited marketing call. So we can all relate as to how people feel when they do receive these out of the blue, when they haven't asked for them. So in the case of Virgo Home Improvement, one individual said, "I was upset because the man was very disrespectful and impatient. I'm retired and I live on my own and it made me feel vulnerable." And another stated that they were currently dealing with a family bereavement. So naturally, the call from Virgo Home Improvements was unwanted, especially because that individual was either on the TPS or they told Virgo Home Improvements previously, "I do not consent to these calls." So now that we've looked at what the regulations require, we're just going to run through a bit of the guidance that we've got as the regulator to help you in order to comply. So we've got a wealth of guidance on our website, ico.org.uk. Many of you will be familiar with it. But the first bit of guidance is certainly really useful, is our guide to direct marketing. And it covers much of what we've discussed throughout this webinar. So certainly have a look at that as a good tool. Similarly, our guide to the privacy and electronic communication regulations goes into what we've covered today, but in a lot more detail. And for those of you that haven't seen it, we've also got a really useful page dedicated to charities, which pulls together all of the guidance that we've got to help you comply with not just the privacy regulations that we've spoken about today, but the GDPR too, or sorry, data protection as well. And it links to GDPR guidance. And finally, for those of you who are interested in assessing your own compliance as a charity with the laws that we regulate, so data protection and privacy regulations, we've got a really useful self-assessment toolkit to help you and other organisations to assess, where you are in terms of the current law. So just so I can get a feel for how much it's being used in this sector, and please be as honest as you want, because it's just out of interest, can I just ask you to agree or disagree? So agree if you've used it, and whether that's using the green ribbon on the top, and if you are, you'll need to clear your status, or type into the chat pane. So if you've ever used the self-assessment toolkit on the ICO's website, press or type agree. If you haven't used it, and that's absolutely fine if you haven't, then if you could either disagree by using the voting buttons or type disagree. So there's a few coming through now.
Okay, thank you, Bethan. So looking at the results that are coming through at the moment, the majority haven't used the toolkit as yet. Perhaps people didn't necessarily know that it was available, but there certainly is the link there for everybody now. And
that's brilliant, and it's really good to be honest, because for those that haven't, if you are interested in completing it, you're more than welcome to come to the ICO to get in touch with me directly or our office after doing so to discuss any areas that you've filled out and you perhaps got any queries about. So the toolkit itself consists of a number of different modules. So you can do one module, you can do two, you can do them all. It's completely up to you as an organisation. So those modules include things such as information security, records management, and there's also a new one on getting ready for the GDPR. But there is also a module on direct marketing as well, which is relevant to this webinar. So you can see an example of the types of questions on your screen. So that one relates to, have you kind of implemented anything in terms of compliance with the PEC regs? So depending on your answers for the toolkit, we then suggest guidance based on what we feel will be useful to help you improve your practice. So if you've had no kind of thought or you've not implemented or planned anything, then there'll be more guidance that we suggest as a result of that. But please do feel free to kind of have a go at that in your own time and get in touch with the ICO if there is anything you'd like to discuss with us. So my contact details are on the screen. So that's the general kind of contact details for the Wales office. But we are a very small office. So if you ask for Bethan, that's absolutely fine. Alternatively, my colleagues in the office will also be able to help. But please do get in touch. I hope today's webinar has been informative and useful. But we are there to provide advice and guidance, and as our WCVA as well. So please get in touch if we can help with anything. But I'll hand back to Emma in case there are any further questions. So if there's anything I need to kind of cover again or answer.
Okay, thank you very much, Bethan. So if anybody's got any questions, if you can start typing them into the chat pane. And I just wanted to mention that obviously the Data Protection Act is changing, and as of May next year, it's going to be the General Data Protection Regulation. And also PECA, or the PEC regs, will be changing, and it's going to be an e-privacy directive. Just wondering, Bethan, if you can give us an update on where the ICO is with that, please.
Yep, so the process for adopting a new e-privacy regulation is currently underway, but until that privacy regulation is agreed by the Council and Parliament, the content is still subject to kind of debate and amendment. So we can't give any detailed lines at the moment, but we do intend to keep our data protection microsite, the DP Reform microsite, updated. For those of you that haven't had a visit to that, that's where all of our GDPR guidance is being kind of channeled through. So if you go on our website that you can see on the screen there, ico.org.uk, if you type in DP Reform, you can sometimes see it on the homepage, but if you can't find it, type in DP Reform and all of the GDPR guidance and any future guidance on the new e-privacy regulation will be posted there. So please keep a lookout on that, visit every now and then, save it as your favourites, and that's a really useful tool.
Okay, thank you very much, Bethan. Okay, in terms of the questions that we've had through then, so there's one, will you be covering Facebook and Twitter? And I know you mentioned social media in your presentation.
Yeah.
So in respect to direct marketing and the privacy and electronic communications regulations.
Yeah, so back to that definition of electronic mail. It can be a kind of text message, an audio message, a video, and it can potentially include marketing by social media. So yeah, the privacy regulations would apply to the use of social media as well.
Okay, thank you. So going back to some of the other questions, will you be covering servers being shared, for example, iCloud and Dropbox?
So guidance on servers kind of more relates to our guidance on cloud computing. So I'm not covering that today, but we've got a really good code of practice on the use of cloud computing, which if you haven't seen on our website, I would really recommend you having a look at. And then, similarly, once you've read that, if you've got any particular questions that follow that, then please do get in touch with us.
And we have a question, do we need to pass this on to the organisations we have awarded grants within the publicity requirements that we enforce? So in terms of if an organisation is distributing grant funds, do the obligations need to be passed on then?
Okay, so it depends who is the data controller in the scenario. And by data controller, I mean, who is the person, who's the organisation that's deciding what information you collect and what you do with that. So if organisation A is deciding that I've got this database of my customers that I'm going to send electronic marketing to, then they'd likely be the data controller for that, because they're deciding who's going to be kind of direct marketed and what's going to be said, etc. If they use organisation B to carry out that on their behalf, then it's still organisation A that's likely to be the data controller, because they're asking another company to follow their specific instructions. So it always kind of depends on the scenario and who's got the amount of control over what information is used and how that information is used. So I don't know whether that answers your question, but it's ultimately up to who's got the control over the kind of information that's being used, who's deciding how that information is going to be used.
Thank you. Hope that answers your question. Another question, is there a direct link for this? I would assume that's relating to the material that Bethan put in the presentation. We can certainly send that link out for the guidance.
Yeah.
So we'll do that after the webinar. A question from Adam. Is tagging people in pictures such as Instagram, Twitter, Facebook for marketing purposes covered by the Act?
I suppose it's using their personal data.
Yes, you can identify that individual from their photo.
You're promoting your aims and ideals by tagging individuals. I wasn't aware that something like that would go on, so I'd need to have a bit more information before I can give a detailed answer, because it depends, if it's a personal Instagram account or if it's a charity's Instagram account, then obviously the rules would be slightly different. But I would be careful, because it's still using their personal data and it's still kind of impinging on their privacy rights, because if they haven't, if they're not signing up to getting direct marketing messages and they're being tagged in something, they've kind of lost that control over their data. So I would be careful in terms of tagging people in messages that are there to kind of promote your aims and ideals as a charity.
So next question through from Simon. If you need specific consent for fax or automated phone calls, can this be covered in one opt-in statement? For example, I consent to receiving marketing materials including electronic mail, faxes and automated telephone calls.
Yeah, thank you for that question. The answer in short is no. So under GDPR, I mentioned earlier on in my presentation, the standard for consent is being raised quite significantly under the General Data Protection Regulation. And one of the requirements, in addition to making sure that that individual is taking a positive, affirmative action to opt in, it's got to be granular as well. So by that, we mean that they would have to be able to consent separately to, back to your example, electronic mail, faxes and automated telephone calls. So you can't kind of bunch them into the same provision. They've got to be granular. So you've got to ask separately and demonstrate that you got consent, not just for general marketing, but for automated calls in particular.
Thank you, Bethan. Okay, so there aren't any more questions at the moment. I believe Judith has provided the link on our other webinars that we've held so far. So that concludes the webinar. Thank you very much for joining us today. We hope that you found it useful and we do value your feedback. There is a link on the screen that you can see there, and there'll probably be one that comes out as well by email. If you can complete the survey, that would be much appreciated. So the next session is on subject access requests, which will be held at the same time, 2 o'clock, on Monday the 23rd of October. And in the meantime, if there are any topics that you want